On August 16, 1996, military airman Eric Nesbitt was abducted from a convenience store near Langley Air Base in Virginia, taken to an ATM where he was robbed, and then shot in the head. The crime was committed by teenagers Daryl Atkins and William Jones, who had spent the day drinking and smoking marijuana. When questioned, both denied that they had killed Nesbitt and blamed the act on the other accomplice. After hearing testimony from both defendants, Atkins was found to be the one to have actually pulled the trigger and was given the death sentence. Jones was given life in prison. During the trial, the defense had presented school records and psychological examinations showing that Atkins had an IQ of 59 and could be considered mentally retarded. They asked for leniency in his punishment because of Atkins' mental disability. When Atkins v. Virginia came to the Supreme Court in 2002, the debate was over whether executing a mentally retarded person was cruel and unusual punishment. Whether a punishment is cruel and unusual is based off the evolving standards of decency that mark the progress of a maturing society. 13 years prior, in Penry v. Linnaugh, the Supreme Court had ruled that sentencing a mentally retarded person to death was not cruel and unusual punishment. They determined these standards of decency by polling rulings of lower courts on the same issue. In Penry v. Linnaugh, the vast majority of states which allowed capital punishment allowed for the execution of the mentally handicapped. Because the standards of decency evolve with society, the lower courts were polled once more in 2002. In 2002, 21 of the 31 states which allowed capital punishment protected the mentally handicapped from being executed. This meant that society found it cruel and unusual to subject the mentally retarded to capital punishment. The court also held that the execution of a mentally challenged person was cruel and unusual in that it does not deter similar crimes, and hence is motivated only by revenge. They reasoned this because the mentally handicapped are less able to learn and adapt, hence other mentally handicapped criminals would not necessarily be deterred by such an execution. The above reasons were passed by a majority of 6-3, authored by Justice Stevens. Scalia, joined by Thomas and Rehnquist, voiced their dissent. They argued that the majority of 21 out of 31 states showed no clear consensus, and that society's standards of decency around the issue could not be read through such loose data. Even if the data could be seen as accurate enough, the Eighth Amendment contained no language on interpreting society's evolving standards of decency. Justice Scalia even went so far as to comment in his dissent that the ruling was based largely on the personal biases of the justices. Another complaint was that the majority opinion cited European law, and that was not sufficient basis for a decision. The ruling found the execution of the mentally retarded to be cruel and unusual punishment, and made it illegal to capitally punish the mentally retarded. It left the decision on whether a defendant was mentally retarded to the individual state. The ruling in Atkins v. Virginia also went largely unenforced in some states, most notably Texas. State discretion of defining mental retardation led to the case of Hall versus Florida in 2014, in which it was found that IQ tests had a sizable margin of error, and hence were not sufficient in determining mental retardation. This ruling not only set a precedent of defining what society found to be cruel and unusual, but also for holding popular opinion in such high regard. It will be interesting to see if a similar polling of lower courts will be used in a future case where public opinion is considered an important factor.